Okay, so for the record, I am going to be recording this meeting.
Okay, and for the record, we are not consenting to this recording.
That is correct. Okay, perfect. So we're here today about the April 22nd long-term suspension that occurred obviously on April 22nd, right? Before we get started, did you guys have any questions for me or anything like that?
Can't think of any. Scott, you?
No,
At least not at this point.
Okay, cool.
Yeah.
Obviously, you guys are aware there was a recording made on April 22nd, 2026 of the comings and goings of Nathan and whatnot. So before I dig into the statutorial conflicts I have with this situation, I do want to go over the actual infraction itself and some issues that I saw after reviewing the recording that I feel are either materially false, inaccurate, or overstated. So here in the email you sent to me, Mr. Collin, yes, we have a claim that Nathan was directed to report to the office after being observed with a lapel mic. I wouldn't dispute that. That's true for sure. And on the way to the office, he used the restroom. Now, again, having the benefit of the audio recording device, I would object to this being considered insubordination or not following directions. He did go to the office. He took a very, very minor detour to a bathroom that was on the way to the office. He didn't go to the other end of campus or, what I'm saying? He wasn't saying, I'm not going to the office. And then obviously he ended up in the office, of course, right? Would you guys agree that that's pretty reasonable?
Reasonable, your description is?
Yeah, like you guys said, go to the office. He went to the office.
Eventually, we didn't go. The expectation is that students are complying immediately with directives.
Well, so when we use the word eventually, though, in our last meeting, we agreed that eventually doesn't account for a minute and 52 seconds when we were talking about it last time, and he was in the bathroom for less than 1 minute and 52 seconds. So, I mean, using the word eventually is the issue I have, right? Just to paint it as some willful act of defiance seems unreasonable, using the bathroom for less than 1 minute, less than 60 seconds. So it's is that an unjustified detour? I don't think so.
Okay.
Do you guys, would you agree or?
I disagree.
You disagree? Yeah. Okay. Let's see here. So it's against the rules to use the bathroom on the way to a place. Is that correct?
Well, I'd given direction that he could use the nurse's restroom if he needed to use the bathroom.
Yeah, he really had to use the bathroom though, right? So he just went to the closest one. Seems reasonable to me. Do you have any comment on that?
I'm listening, just taking notes.
Okay.
No questions so far.
Okay. Let's see here. This next claim that you told him that he could use the nurse's restroom, did that happen in the hallway or the main office?
The hallway.
That happened in the hallway, not the main office. And then I see here that you have a claim that Nathan did not comply with this request and entered a student restroom in the hallway. Mm-hmm. And then he went directly to the office. That is an accurate statement of what occurred?
Yes.
Okay. This next thing is that he refused to turn off the recording device. Obviously, that's true. I wouldn't disagree.
Okay.
Nathan walked out of the assistant principal's office and was instructed to remain in the office. So after reviewing the footage, I would object is that blatantly false. That didn't happen, right? So what occurred was you had called me on the phone, Mr. Collin.
Yes.
And prior to that, Nathan disclosed to you that he was recording the conversation. You expressed that you did not want to have a conversation if it was recorded. And he said, okay, I guess I'll go back to class. And he left. You were on the phone with me. Yeah. No other staff. You didn't say, hey, stop, you can't leave. No one else did. Mm-hmm. He proceeded to class. Would you say that's a reasonable assertion of it?
I will say that I wasn't absolutely on the phone with you. I didn't say anything to him. Other staff reported that they instructed him to remain in the office.
Other staff, after reviewing the audio footage, were mistaken or lied outright, one of the two, right? Could have been they were just mistaken. Maybe they meant to say something and didn't. But regardless, the audio recording device picked up no, you must stay in the office, anything of the sort. So I would object to that as materially false. Next, the idea is, again, this kind of just builds on the other statement that he went to his first period class. Again, I wouldn't disagree with that. I think that was a reasonable position for him to take, given the fact that at the time you were unwilling to speak with him. So, he went to his class. In his class, I believe it was Mr. Stevens' classroom, if memory serves. Mr. Stevens seemed really happy to see him. They had a public conversation about like bicycles and random stuff. I didn't hear any material disruption. This was obviously before the actual class started. So the teacher was talking to Nathan, a couple other students, and just kind of, shooting the shit, generally speaking. Mm-hmm. So he never instructed Nathan to leave. He never said you couldn't be in the classroom. Nothing of the sort whatsoever. Once class had started, and it was brief between the time they started and he wanted to grab some water. So he left the classroom after informing Mr. Stevens that he was going to go grab some water, left the classroom to get some water, and then when he returned back, his backpack was on the outside of the classroom and the door was locked. At this point, Mr. Sanderson, or yourself, I'm not sure which, because you guys actually have really similar voices on recording. Okay. One of you, not sure which one, directed him back to the main office. Nathan then asked the staff member, again, you or Sanderson, not sure which, why, like who took his bag, what kind of happened with his bag. They said something to the effect, not something, exactly, and I quote, "You don't know what you're talking about, you need to go back to the office." At which point, Nathan said, "Sure," and went to the office, right, walked to his office. So in the infraction, it's denoted here that he was being insubordinate in some way, shape, or form during this action, or refusing to go to the office. Again, materially false. He didn't refuse to go. He did ask a question. I wouldn't call that an outright refusal to go somewhere. He did go, and obviously, as we know, he ended up in the office shortly thereafter. The next big issue that I have with this is the claim that he used the restroom without permission while in the office. And this would be the second time he was in the office. So he had a conversation with you, Mr. Cullen, about the recording devices, the why he's doing it and all that sort of stuff. I'm sure you remember the conversation. And then the police showed up during that conversation. The police, he asked them if he was being detained, and the answer to that question by the police officer was yes, you are being detained. So I would say at that moment, legally speaking, he was no longer in the custody of the school in any way, shape, or form. He was under the detention of a police officer. When this bathroom incident occurred, he said, "Hey, I know I'm detained, but can I use the bathroom?" The police officer said, "Do you mind if I follow you there?" And he said, "No, it's no problem. You can follow me there." And the police officer allowed him to use the restroom. I believe it was the nurse's restroom, but it was. Yeah. And she supervised that whole encounter. So yeah. I would say that including a infraction for following the law, because when you're detained by a police officer, you can't just be like, "I'm going to go over there." You're detained, right? You can't go anywhere unless they say you can. So I would also say that is not something that I think is supported by the facts, the recording, or the law. He wouldn't need to ask permission of staff to use the bathroom when he's in police custody.
Okay. But to be clear, I don't think that's included in the write-up description.
Perhaps I'm talking about a different, let's see here.
The description of the write-up kind of ends around the time he was directed to return back to the main office from his first period class.
Did from like when you guys originally did this to Skyward, did you add that in the original one?
I've not made any changes. No. I can check Skyward.
Yeah, could you? I could be mistaken on this one. I might have to take the L on this issue, right? But I mean, if it's not included in Skyward, I guess I would have no objection to that part, obviously. Mm-hmm. If it is included in Skyward, I would like that changed, adjusted, that part of it removed. Those are kind of like the factual basis of like why we're here. Do you guys have any questions about the points I went over for the email specifically?
I can't think of any right now.
How about you, Scott?
No, I don't have any questions on that. No, they do concerns.
Okay, excellent. Next, we're going to, I think we need to dig into like some of the policies, prescriptions, and laws that were cited in this email. I think it's very important. Now, are you guys super familiar with what due process is, what it means, how it functions in general?
In general.
Scott, you as well?
In general, in the context of schools.
In this context, I think that it's really important to have both notice, which I think has been satisfied in this case, right? We're having a meeting about it, that's notice, and opportunity to defend. Now, a part of notice, though, is understanding the charges against you, right? Like, it's super important. If we don't understand the basis of the charges, and obviously in this case, they're not charges, they're infractions, but same criminal law, whatnot. I would say that there would be a huge denial of due process. So I noticed here in this email, you guys are citing a couple of RCWs. RCW 28A 6350201, also RCW 2A 6000156 subsection D, which of course is what governs long-term suspensions. And when we're looking at these long-term suspensions, I guess my first question is, what is the health or safety risk that Nathan posed that day? I would like to have that direct question answered because it's not really in the infraction.
Right. So it's my understanding of this RCW that when students are interfering with the orderly operation of the school, when they're preventing school staff from fulfilling their assigned duties, such as supervising other students, especially at a time when before classes have started, students are throughout the building. All hands are on deck for supervision when this type of behavior occurs, and many staff are pulled in to address an issue. It compromises the overall orderly operation of the school.
Okay, so I'm wondering if maybe there's a little bit of a misunderstanding on your part when we're talking about long-term suspensions. Now, they're wildly different than short-term suspensions here in the state of Washington. They have a much higher threshold. They have very specific facts that need to be established in order for them to be legal, binding, so on and so forth, right? So when we're looking at this, a long-term suspension, of course, is anything that exceeds 10 days. So obviously this being a 15-day situation would be falling under that category. Now, I think it's important to note, and again, this would be a question that I would ask you. So under RCW 28A, I'll give you guys a moment to write it down if you want. 600, yep, 015, subsection 2, under short-term suspensions, there is a term limit, an amount of suspensions that a person can be subjected to in either a semester or a trimester. In this particular situation, the limit is set to 10 per trimester. You guys work on trimesters, correct?
No, we work on semesters.
In that case, it would be 15. Yeah. Nathan, of course, this semester, this semester has been excluded for 22 days, 22.6 days in short-term suspensions. Now, I'm making a meaningful distinction here between the short-term suspension and the long-term suspension because they are legally different.
Yeah.
Now, my concern is that you guys are using a long-term suspension through your discretion to circumnavigate the limit on short-term suspensions. How would you respond to that?
Respond is no. We're responding in accordance with RCWs. I also, based on my own accounting, I don't see that total number. You said 22 days of short term.
22.6, yeah.
I've got 13.9 is what I've calculated.
Are you counting the 2 weeks leading up to this situation of the 2-week suspension?
I have not counted the
Well,
long-term suspension because that's a separate category.
Sure. But you remember we had 10 days of short-term suspension directly leading into the 2-week long suspension, right? Plus we had additional instances beforehand.
Yes.
So by my count, it was 22.6. saying it's only 13.9.
0.9 is what I have. Look at the attendance.
I mean, I'll have to go through Skyward and check on that, but I mean, if that happens to be the case, that happens to be
I
the
can look
case.
into that too, just to double check.
So, let's see here. What specific facts support a finding of a imminent danger or safety risk? Because that's the legal standard for long-term suspensions. What are the specific facts alleged here? Imminent danger or safety risk.
Right. Yeah, it's the response, right, of building administration and other staff to Nathan and his lack of refusal to stay in a location, to turn off equipment, the recording equipment, hand it over.
How is that a safety threat?
When multiple school staff have to respond and are pulled away from their assigned duties, that begins to put the rest of the building at risk.
So it's the recording device specifically that is the imminent threat?
Not the device itself, it's the refusal to comply with staff requests.
So if he has the recording device on and he refuses to turn it off, that's like an imminent danger or safety threat.
That is one component of this entire write-up.
Well, the rest of the write-up, as far as like not complying, he did. Like objectively, he went where you guys told him to go. So there's not a lack of compliance.
Right. Well, based on what was reported by other staff that I had talked to about this incident, they reported that they had made requests of Nathan that he did not follow.
Are you willing to listen to the audio recording that disproves it?
No.
You're not going to do that. Okay. Well, that seems seems a little wild. So then help me understand what the exact imminent safety threat is. It's the not going to the office quick enough.
Yes.
So
coupled with not turning off the equipment, leaving the office, not returning to the office when instructed.
So what about that is, I guess maybe I'm confused, like how you guys are using the word safety versus my understanding. As far as I understand, when we're talking a safety risk, we're talking about, threats, violence, having a gun, things like that. These would be safety risks, like massive ones. Or an imminent danger would be him, about to attack or going to attack someone here in the near future. Like those are extreme, positions. Whereas just going, I'm going to use the bathroom real quick and then go to the office, and we're talking, less than a minute detour. I don't personally understand how that's a safety issue. I mean, was he like running with scissors, anything like that? At least something. So, can you help me understand that? Like, why is that a safety threat? Using the bathroom briefly before you go to the hospital or go to the
Right, so
office.
it's requiring multiple staff to respond to a situation where a student is not following directions.
He was following directions.
Okay. Again, based on the information that I have not during this whole.
Correct me if I'm wrong. If a staff member says go to the office and then you go to the office, that is complying, correct?
Yeah, I mean, it's what immediately complying is part of the issue. He's not immediately complying. He wants to go out to the office. He's told that if he and correct me if I'm wrong, Scott, he's told that he can use the bathroom in the office, use the nurse's office to get down to the office. Doesn't do that, goes to the office anyway. He's directed to stay in the office and leaves and goes to class, or leaves and goes to the bathroom, or whatever. All of those things are a disruption to the environment. And the insubordination pieces, he's not doing what he's asked to do with the recording device, and I know I don't want to sound like a broken record. All those sorts of things are suspendable offenses.
Sure.
And if you leave an area where you've been directed to stay, that's a suspendable
So
offense. We don't do this stuff right out of the gate either, right? I'm just giving you my own
so I
experience,
guess,
right?
I
We
guess
don't do that stuff out of the gate.
My big issue is,
Yeah.
even if I accept your premise that this
Yeah.
is all like against school policy, it's against the rules, right? And I take your position that is in fact punishable. It still would be barred from a long-term suspension punishment, because from what you're telling,
That's
you're
what I'm
describing his behavior, sure, but I'm not seeing the imminent threat, the danger, the health risk, and that's what's required for a long-term suspension. So I think statutorily speaking, it falls on its face, because there's no. And then of course, there's another huge problem with this, which is the events of April 14th in conjunction with this. So when you guys say it's an imminent, like it's a disruption to the school, or it's an imminent threat somehow, it cuts the April 14th. Now, Mr. Collin, this is an email I received from you on April 14th, and that's the infraction for the events of April 14th. Now, on this day, you guys called the police and tried to have him removed from the school. He had his audio recording device on. You were aware that it was on. He was recording. All this was disclosed. You called the police, and the police declined to come and remove him from school grounds. He spent the whole day here at school with his audio recording device hooked to his shirt, throughout the whole day. No material disruption reports whatsoever. No conflicts with staff whatsoever. No reports of bad behavior whatsoever. So he had a totally normal day, and he was recording. It cuts across that narrative that just simply refusing to turn off the recording device was a material disruption. No classes were disrupted whatsoever. So how would you guys respond to that? We have one example where he has it, no disruptions, no write-ups, no nothing, the whole day. Where on the April 22nd, exact same thing, all of a sudden it's an imminent threat, a danger. How does that work?
Well, I mean, another side of this is the unsafe environment that's created when he is out recording throughout the building.
How is that unsafe? And why was it unsafe on the 14th?
Well, it was all part of it. And we tried to send him home, right? You refused to pick him up. We did contact the police to look at next steps. We were doing, I feel like, everything we could.
But he was at school and had no disruptions or problems the rest of the day. Is that correct?
So can I question? So your premise is that since it wasn't unsafe, like there wasn't a danger involved, that the long-term suspension does not apply
Correct.
to this situation. Okay.
Yeah.
That's what your concern is. The major one.
I would say that is a concern.
Okay.
I feel like you guys are using this long-term suspension just in a discretionary way, right?
Okay.
In discretionary way,
Okay.
which the RCW 28-600-015 subsection 4 explicitly forbids. Exactly, right?
Okay.
And I understand that we're having a recording dispute and whatnot, but to say that this is a safety risk or a material disruption, I find it to be dishonest. Because I know on the 14th, he had his recording device on the whole day, and you guys were aware of it. I assume all the staff was aware of it as well. And there was no material disruptions, no safety, there was no safety risk, no violence, no threats of violence. He had a completely 100% normal day. Nobody even accused him of anything, which is rare, actually. I find that to be interesting too. Staff are aware he's recording, he's in class, and 0 reports that are materially false. Not a single one for the whole day, which to me is very disturbing. It feels like you guys are more interested in protecting teachers' ability to arbitrarily say whatever they want based on their own feelings and punish kids and deny an objective record for review. That seems like a big issue to me.
Okay.
Another RCW, actually, you know what, hold on. Before we move on, I actually really need a direct answer just because I want to make sure I fully understand. So how is having a microphone attached to your person an imminent threat or danger?
I see it as putting school staff and other students at risk.
Risk of what?
Risk of their privacy being violated.
So we know, right, when a teacher's in the hallway and there's 400 kids around, walking around, talking, doing their things, their privacy is not a concern, right? And also, if we're going to bring up the privacy thing, you guys obviously have security cameras posted throughout the school, which are accessible via public record requests, which we all know that true. So, I mean, I could request video footage of any time, any place, anywhere I want at the middle school. So, I mean, we can be...
But there are limitations.
There are limitations, except for classrooms.
Sure.
Yeah.
Maybe not classrooms
bit, yeah.
specifically. But again, the law turns on whether or not something's private. And I think making that blatant term is ridiculous. And even if I were to accept your preconceived notion that it is somehow an imminent danger for someone to have their, a conversation or something they say overheard in the hallway, even if I were to accept that premise, I would say that I'm not publishing these recordings that Nathan has gotten. Never said I was going to, haven't done it once. I've literally, they're for you guys to listen to, for you specifically. They're not for publication, they're nothing like that. It's so that I can give you guys an objective record when a teacher makes a false report that has happened numerous times towards my son. So when you say it's a privacy concern, what about the false report concern, right? And again, even still, a privacy concern is not an imminent threat or safety risk. You could say that it's a privacy violation. You could say that, but that doesn't meet the statutory definition of long-term suspensions.
Okay.
So even if we were to make that claim and I were accepted as true, which again I reject it and think it's not true, but even if it were, it still wouldn't justify a long-term 2-week suspension.
Okay.
So again, what was the immediate harm or danger?
I've described it, I think, as much as I can.
Yep.
Based on my understanding.
The disruption pieces, and even if we go beyond the recording pieces, the insubordination pieces definitely fall under that area. I mean, a student who isn't going to follow, staff or administrators' directives could become an imminent danger or threat.
Well, so
that's,
the
I mean,
statute,
that's you.
the statute doesn't say could become an imminent threat or danger. Anyone could become an imminent threat or danger at any time. Anyone, at any time. That's not the standard. The standard is an imminent threat or danger. Imminent, right?
Okay.
There's a thing occurring that's very, very important.
Okay.
So these nebulous claims that this could happen, this could maybe occur with absolutely no foundational system behind that belief, doesn't meet the legal standard for long-term suspensions.
Okay.
So
I think we've got that. Yes.
okay,
I think we've got that point.
But in order for us to do a proper appeal, I have to understand either what the immediate threat or danger is, or for you guys to tell me.
Well, we've talked with you about the imminent disruptions, the imminent leaving an area where they're not supposed to be or comply with an administrator. To me, that's a danger.
I point
because he could do anything. I point you to April
14th, where he had an audio recording device. There was no disruption, nothing like that. Again, we can't just say someone might do something, therefore we're going to punish them. That's not how the law works.
Okay.
It's just not, objectively.
Okay.
So
that's what you're appealing. Yeah.
But that's why we're appealing.
That part. Okay,
yeah, that's why we're here. Yeah,
I gotcha.
100%.
Okay.
Did you guys have any health concerns on April 22nd?
In what? I guess go ahead. What do you mean by health concerns?
Health concerns in general, right? Just like the word health, right? People's health, their physical health, breathing issues.
Are you referring to Nathan's health? Or?
Yeah.
Health issues in general. Yeah, maybe Nathan's health could be the health of another student, right? Were you guys concerned if maybe he remained there, he was going to, start a pandemic or something? Was there a health concern?
In that sense?
Not a physical health
concern. Not a physical health concern. Yeah.
So no physical health concern on April 22nd, 2026.
Yeah.
Yeah, that was
in there,
aware
yeah.
of, yeah.
Okay. Were you guys concerned that he was going to commit any violence that day?
No, I was not concerned.
You weren't concerned about violence? Were you concerned that he was going to injure staff in any way, shape, or form?
No.
You weren't concerned about that? Were you guys concerned about any other physical aggressions on like police or staff or students, anything at all?
No.
Okay. Did you guys do a written determination for an imminent danger finding at all? Physical threats we're talking about here.
You're referring to physical threats?
Physical threats, violence, anything like that. Any written determination whatsoever.
That I can see.
What was the material difference between April 14th when he was at school all day with no disruptions, no problems, no threats, no violence, and April 22nd when the exact same issues were presented? What was the material difference between those 2 days?
I see the material difference as being on the 14th, you refused to come pick him up, and we were trying to.
Well, did I refuse to pick him up on the 22nd as well?
You did.
So that's not a material difference.
But the difference is that we had a plan then with law enforcement about how to proceed. I mean, I've never worked through a situation like this, and so then we had a plan.
So the only material difference was that law enforcement was willing to remove him on the 22nd as opposed to the 14th.
Yes.
So would it be fair to say that there was no material difference between the 14th and the 22nd other than law enforcement's willingness to come and get
I
him?
haven't dug down into all the details here to say that, that there was no other differences, but in general, right, we had similar behaviors, right?
Okay. So as far as you could tell, no material difference, but if you were to look into it, it's possible you could change your mind.
Yes.
Okay. Now, on April 14th, Nathan was accused of saying that Ms. Bachmeyer was a bad principal. Can you explain to me why that's an imminent threat or danger?
I don't think we made a claim that's an imminent threat or danger. We think that that's
It's part of the escalation that led to the...
insulting school staff, right? It's not talking respectfully of school staff. It is something we expect of all our students.
So is it your position that students, if they have a criticism of staff, are not allowed to share that criticism?
We've had similar conversations before, and I think, and Mike, free to chime in, but in this, if parents or students have a concern about a teacher or have a criticism, then I think that there is an appropriate pathway to that. That's calling a meeting with an administrator, teacher, sit down in an office, private office, let's have the conversation, let's work out the differences. It's not in the open space in front of other students, publicly insulting and stuff.
I don't want to beat a dead horse, but my one comment to that would be that Ms. Bachmeyer definitely publicly accused him of sexual harassment. So publicly saying, I don't think you're good at your job, to me, is totally within the bounds of Tinker v. Morse.
Okay.
But that'd be my thing.
Okay.
Now, when you guys were making the decision to long-term suspend Nathan, did you guys consider why he was using the audio recording device?
I think at that point you had expressed why.
Did you factor it in
Yes.
to your decision?
Yes.
And did you find his reasonings to be like reasonable, or did you think they were unreasonable?
I understand the concern. We have to follow the law, however, in our investigations, and that does not include using audio recordings. It's about interviewing students, staff. I mean, we've had this conversation.
Yeah.
That's my limitation when I'm doing an investigation. So, like, I've listened to Nathan, I understand the concerns. However, I am limited in
Sure.
how I can proceed with an investigation.
What law prevents you from reviewing a recording in an investigation in a school issue?
Was that this recording was obtained in an unauthorized way.
Well, that's unauthorized based on school policy, not law. Correct?
It's school policy.
Yeah. So the only thing stopping you from reviewing the evidence is school policy. Because earlier you said it was the law.
Yeah.
But it's not the law.
Well,
it's school policy.
there's a lot of pieces involved with that, though. And you know, when you talk about BETNA, I mean, we've been through those pieces. We do not, district does not recognize, nor do we need to recognize at all, audio recordings at school. I mean, I mean, as you know, right, we're on that hill, and so those are the things that we're not going to change the policy and allow students to begin recording school day at any point anywhere in the school. They're not authorized to do that. Okay, so any conversation about it to me seems like it's been asked and answered. That's just
sure.
Anyway,
we'll move on to RCW 28635020. Now, in the email you sent to me, and please correct me if I'm wrong, it seems like you're citing that as a law that makes it illegal to disobey school directives. Is that an accurate summation of your position?
Yes.
That is an accurate.
From a school administrator.
From a school administrator. Now, you understand, I've read it. I've read it. It absolutely doesn't say that. Not even a little. It specifically has to do with a person who is immediately threatening, using drugs or weaponry at school. It has nothing. It's not a general statute in which empowers teachers to order people off public property who are legally allowed and required to be there. So this authority that you cited is just wildly wrong. It's just incorrect. Are you claiming that like Nathan somehow violated this statute?
So I'm just refreshing my memory here. It's my understanding that that law governs situations in which someone fails to comply with a directive from the school administrator. That's how I read that.
So I guess I would ask, what drugs did you guys find him using at school? Any drugs?
No drugs.
Was there any threats?
No threats.
No threats. So what justification would you use that RCW under when it has to do specifically with threats, drug use? It's failure to leave when directed lawfully by an administrator while you are using drugs, weapons, like extreme behavior. So like if we're not concerned about any of these extreme behaviors, I don't know why we're citing this statute. It doesn't say you must obey all school directives from staff members.
Yeah.
Yeah, and that was in response, to your questions. It's not in, to be clear, it's not in the Skyward write-up.
So, it was in response to my questions. But, so you would agree that Nathan didn't violate this RCW then?
Go ahead, Scott.
I can't conclusively answer that right now. I mean, I would have to go look at that again.
Okay. But do you suspect him of drug use that day?
No.
Do you suspect him of violence that day?
No.
Okay, so since those are the cornerstones of that
We'll take a look.
RCW.
Based on your
Based on what you're saying and your interpretation, yes.
Okay.
I see where you're coming from.
Let's see here. And you guys have cited this RCW to me on numerous occasions. This is RCW 9.73.030. And this governs recordings in private conversations. So it's been cited to me many times as a blanket ban on all recording in public schools. Of course, this RCW has no mentions of public schools whatsoever. It has no mention of school grounds or how it interacts with school in any way, shape, or form. It turns specifically on whether or not a private conversation is private or not private, which has to do with the amount of people that can view or hear the conversation, has to do with the contents of the conversation, where the conversation occurred, and I don't know why you guys are coming to the conclusion that this is a blanket outright ban on all recordings in public schools, disclosed or undisclosed. Can you please explain to me why that RCW means that, since it has no language about that whatsoever in it?
Going based on the guidance of our.
Yeah, on our, yep,
And
based on their guidance, yeah, recordings, where it's totally lawful for us to have a school policy around, and just like every other school in the
We're not talking
state,
about policy.
and probably the
We're talking about
nation.
law.
Okay, but general law doesn't necessarily,
So why are you citing
yeah,
it then?
yeah. No, I'm not saying it doesn't necessarily nothing. I'm just
Okay,
saying,
so-
because it pertains to recordings in school, and I believe I'd have to take a look at it again, to review.
It doesn't.
Because we got a lot of stuff. We'll
Doesn't
take
say
a
anything
look.
about school.
Okay,
Not even a
so,
little.
so you made that point as
Well,
well, which we've,
hold on.
said as a district, we're
We-
not gonna
we have-
allow.
We have to talk
So-
about it a little bit more, right? So the claim
No,
is that you guys got
yeah.
this direction from your school attorneys, right? That's what you're saying? So when I bring your attorneys into a deposition and ask them if they gave you that advice, are they going to tell me that they did give you that advice, or are they going to tell me, hell no, that would be
to them,
crazy
yeah.
advice to give my client, because that's not what it is. So I got to be honest, I think you guys are making that up. I don't think it's true.
Okay.
I know your attorneys
Okay.
personally. I've spoke with
Yeah,
Sarah
you
Mack
have.
on numerous
Yep.
occasions. Sarah Mack is a
Yeah.
very intelligent legal mind. No shot, 0% chance, that she tells you this RCW is a blanket ban on recording in public school, because that's not what it is.
I mean, I'm not an expert on RCWs here. I didn't,
Yep.
didn't cite that particular RCW.
Okay.
You have many times.
Okay. Okay, so we have stood on that we're not allowing recordings in our school buildings, anywhere in our school buildings.
But not based
so
on
we've
this
already,
RCW?
okay,
But is it based on
Yeah.
this RCW or
that I
the
can't tell
policy?
you. I'm just telling you, yeah.
Okay.
School policy, I'm just telling you. I
So
don't-
did Sarah
So-
Mack advise you guys that this RCW works the way you've
We've
described it?
never
to
had
me?
that
Yeah, I
conversation.
haven't had that
So
conversation.
then why did
Yeah,
you
no.
say you did?
We've had other conversations.
Yeah.
With,
Yeah, we'll refer you to our district and lawyers on that one.
Okay,
Okay?
so
And that's
is
the
it-
best answer you're gonna get out of us today.
So is it fair, is it fair to say, when you guys told
Yeah.
me that
Yeah.
you spoke to Sarah Mack about this RCW, that was a lie? Is that fair?
no, I never said
No,
You did?
no.
I'll send
Our
you the-
attorneys have talked to us about this, is that we are willing to go to court over this, correct? I mean, we are, and because we're already in court.
Yeah, we're obviously in
So,
court,
so
yeah.
there we go.
Yeah.
That's what that's what I will say is that.
But
So-
you're-
So that's where it's winding up. We're not gonna,
So
we're
is
not
the
gonna
earlier-
continue to do the back and,
Is
you
the
wanna
ear-
say, oh, you guys are, no,
I'm just trying to
I'm just
understand.
telling you, I've never talked with Sarah Mack, so.
Okay, and neither of
Okay,
you?
yeah.
Okay,
Yeah,
so she
so there,
absolutely didn't tell you?
Not
that
to us.
RCW. Okay,
Yeah.
cool. So I
Yeah.
don't know why you guys said
Yeah, okay,
that. Okay. What time are we at?
yeah, we gotta be out of here at 2, so we're at 1:46.
Part of due process is getting through the whole process, not part of it.
I understand that, but we also have other commitments.
I mean, we can always continue the meeting if we get to that point and we're not done, I'm fine with that. Again, this is, long-term suspension is a very serious thing.
I got you.
And you know
I
what?
got you. We need
to
to
me-
take a look at that.
To meaningfully review it might take more than 1 hour of your time.
Well,
I mean,
according
let's
to
just-
you, it might take more than an hour of our time.
Why?
I mean, I think we pretty much got some of the reasons already, right? The imminent danger you're not seeing, I think that to me seemed to be like one of the main ones about the long-term suspension. You're not seeing where the danger piece applies, that your kid's not a danger, he's not violent, he hasn't threatened anyone, all of that, right? Which we haven't seen any reason to disbelieve that either. So, anyway.
What makes, in your guys' opinion, well, again, I guess the problem is I can't tell whether we're talking legally or school policy. Because like there's a lot of confusion.
Those are good.
there.
Oh, hey, it's not cutting, yeah.
So I need to know
Not
what
cut and dried, yeah.
I need to know what I'm
Yeah.
defending my son against. Am I defending him against legal claims, or am I defending him against school policy violations?
Yeah, policy violations or both is what I would say.
Okay, so
Yeah, not being a lawyer,
which
so-
RCW specifically are you guys alleging he violated?
Well, one, insubordination.
That's not an RCW.
Whatever grounds, but there's grounds in discipline. There might not be an RCW.
Well, there's-
There's grounds in discipline in our school policy and procedures.
Okay, but you
that
told me,
pertain to insubordination.
you told me both law.
Okay,
You told
yeah.
me law and policy, and then I asked you which law. You said insubordination. There is no law against
Right,
insubordination.
exactly,
Doesn't
right.
exist.
It's in school policy and procedure.
Okay, so the law has
School
nothing to
board
do.
policy and procedure.
So the law has nothing to
Yes.
do with it.
Well, the law supports, right?
Yes,
School policy and procedure is built or generated, created based on law, right?
Do you know which laws?
If we go digging for them and
yep,
It's just hard for me as a parent to defend my son against these false allegations and everything else that's been going on at this school if I don't understand exactly the basis for the suspension itself. Because we're going over it.
and that's what I think we're agreeing, we're gonna take a look at that. We're gonna take a look at all this information that you're giving us, and we'll be getting back to you on that in a couple of days.
Well, okay.
Okay,
But
and I mean, from there, I'm just saying,
my son's been
Yeah.
out of school for over
Yeah.
2 weeks straight.
yeah.
Over 2 weeks.
Because he continues to bring a recording device and not follow directives.
But again, that is not justification for a long-term suspension. And
Okay.
and more importantly, you guys
Yes.
are out of short-term suspensions. You're out. You're going to have to figure out a different way of doing this. He is going to be allowed to come back to school, one way or the other. We've got court on the 8th, right? I know for a fact, like I'm 99.9% sure the court is going to order him back with or without a recording device. He's coming back, right? Well, actually with. I'm 100% certain it'll be with.
Yeah.
And you guys have ran out of disciplinary ability. You've exceeded your 15 days at this point. Because even if we want to turn this short-term suspension or this long-term suspension into a short-term suspension here in the near future, you've exhausted your days.
Okay.
He's required. So let's assume you were right about your 13 days. He's been suspended for more than 2 days, which would put us at 15. Which means literally, if you guys decide to convert this into a short-term suspension, he's required. He can come back to school the very next day because you don't have any more short-term suspension days. And I mean.
Okay.
Are you guys even aware of that?
Yeah.
Were you
Well, you
aware
brought-
of it before this conversation, I should ask, about the short-term suspension limitations?
yes.
You were aware of that? Did that factor into your decision to turn it into a 2-week-long suspension? No. Despite we have absolutely zero facts to support a long-term suspension.
I disagree. I believe we have the grounds for a long-term suspension.
Okay. But you also agree there was no violence, no drugs, no alcohol, no weapons, no threats, right?
Right.
I mean, it's an oxymoron. I just don't know what to tell you.
Okay.
It's an oxymoron.
Okay.
It's a nonsensical position. I mean, I guess you're allowed to have nonsensical positions, but I mean, Jesus. I mean, have you actually, just out of curiosity, any of the RCWs that you've cited to me for justification for these things, have you read a single one of them? You've read them all. Are you sure? So when you were reading the long-term suspension and you saw specifically in there the qualifying conditions for it, which one were you pointing to? Said, he did that. Which one?
Right. Yeah, I can't remember the letter, but yes.
I mean, I've got the letter for you if you'd like. I mean, I can literally give it to you right here. I mean, if you could point me out, there's the letter. If you could point to which part of that RCW you're citing, I would be awesome. I would love to know.
No, not rather the RCW.
Oh yeah, for sure, for sure.
Pull it up.
And then while he's doing that, I did have one other question for you in regards to the RCW 9.73.030. Are you claiming that every hallway directive, classroom instruction, and office interaction at the school is automatically private under that RCW, even when other students, staff, and members of the school are publicly there?
Yeah, I do, because it's not everybody's just allowed in school to come do what they want to do. They're here for school. They're here for, I mean, it's not coming in, walking off the street. You know, the street, obviously, off school grounds, yes. On school grounds, no.
So
everything that, because we're in charge of all of that, right? So we can't just have everything is open public. we're responsible for the safety and health of the
Well,
building.
remember, there's a distinction
Yeah.
legally between the word public
Yeah, yeah.
and a private
Yeah,
conversation,
yeah,
right?
well, yeah,
So
yeah.
like, I'm asking you specifically, are all conversations private in school?
All conversations should be had without having the concern that it's being recorded, yes.
Okay,
That's what I'm saying.
yeah, but that's
Yeah.
question dodged. Are
Yeah.
they private?
Well, I mean, I don't know, it depends, I guess, on private, public, like, what do you mean by,
A private
you know,
conversation.
a public conversation?
Well, like what we're having right now, this is a private conversation. The
mhm,
door's
yeah,
shut,
I
there's no
understand.
one else in here,
Any-
it's private, right?
Any conversation that's in the office, any conversation that's in the hallways, any conversation that's in the classrooms, I'm gonna say, yes, those are deemed private because they are occurring at school.
So then
Now, I'm just saying, that's where I'm at on that. So you're gonna say, well, that's not necessarily private, because private could be something different. What we're saying in the lens of recording, yes, I would consider them private.
Well, recording
Because
is.
nobody is,
So the recording has nothing to do with
okay,
whether a conversation
I'm just saying if
is private
that's the
or
reason
not
for
private.
the question, is because, so you can have a recording because it's considered public, not private.
The purpose of the question is I want you to be on the record saying something that ridiculous. That's the only
Oh,
reason I
see.
asked the question.
Okay, then I'm done.
Yeah. So go ahead, Mr. Scott, about that RCW. Which section in that RCW are you claiming Nathan violated?
Yeah, it's under 6. 6D. My understanding.
Okay. So then, I mean, the obvious next question is, what behavior did he exhibit that impacted the health, which, by the way, earlier you guys said he didn't do, or safety of other students or educational staff? What did he do that was unsafe?
Right, so we had the safety discussion by necessitating the response of other administrators, school staff to that situation, pulling them away from their other duties, supervising other students around the building, right? That
What was your safety concern? Were you concerned that he was gonna like trip and fall?
No, it's not about his safety. It's about our responsibility as school staff to supervise the students to ensure their safety around the building, right? And when school staff are pulled into a situation like this, to address it.
Well, hold on. We know from the 14th, you guys didn't need to send 3 or 4 teachers to watch him walk down a hallway to the office, because he did the whole day on the 14th without that problem. You guys chose to do that. He did nothing to warrant that level of interaction. So like, what was the safety concern of Nathan before 4 staff members were following him around? Like, what was the concern? The safety
We
concern?
also have the safety concern around the recording device, right?
Okay, so it's your position that the recording device is like an anti-safety field?
We have the concerns of the privacy violation that it,
Okay, it says safety, not privacy. Long-term suspensions require safety violations, not privacy violations. So what's the safety concern?
staff feeling safe to do their jobs.
Feeling safe, that's also not the limitation.
Yeah, and-
Feeling
and-
safe has nothing to do with it.
I would say that safety is a feeling, not a fact.
You would say
Yeah,
that
that's
safety
part of it. There are
requirements is
facts, but it's also depends on that person.
So it's
how they feel, how they are feeling.
So then Nathan could
Yeah.
be standing in the hallway by himself doing nothing, and a staff member could go, "You are making me feel unsafe, and therefore we're going to long-term suspend you." Is that
Well, if
true?
He's there for no reason, but if he's there with a recording device, I could see where a staff member may feel that way, depending on the staff member.
So it's the recording device specifically we're talking about here, nothing else, because he wasn't threatening anyone, wasn't harming
We don't
anyone.
have any. No, we don't have any.
No,
that.
just the safety
Yeah.
concerns of the recording device.
And coupled with not following directions.
Yeah.
How
Coupled with the
well,
insubordination.
Well,
So
there
it's
was
not
no
just a-
insubordination.
Well,
Like,
okay.
how confident are you guys that your definition of
Mm-hmm.
safety is going to match the definition of safety of this RCW? Do you think when
I
our
guess we
legislators...
find out.
Find out, yeah.
I mean, we are
Yes,
going...
we'll find out,
Yeah,
yeah.
we're definitely going to find
Yeah,
out, for
yeah,
sure, 100%.
Yeah.
So,
Yeah.
and then my final point to all this is, now that
Yeah.
we've said that safety is a subjective feeling, I would like to know why you guys never acted or did anything on the safety concerns my son brought to you guys on the HIB contracts, the HIB forms, where he said he felt unsafe. I'll grant you, subjectively, entirely subjectively. There was no
Yeah, but-
material basis for his feeling other than his feeling. Why did you not act on those in any capacity whatsoever, yet you act on them when it's staff? So we have staff say, I feel threatened or unsafe, and boom, kid gets suspended. But when kid says, I feel intimidated, I feel harassed, I feel bullied towards a staff member, all of a sudden we have to look at the objective fact of the matter. Can you guys explain to me why that is?
Yeah.
Yeah, I disagree with that premise.
Yeah, I think our kids feeling safe is something that we always follow up on, so.
How many
And we
teachers-
always investigate.
How many teachers
or should.
have been punished, corrected, based on my son feeling unsafe at school? How many times?
I think you said you know the answer to this.
Yeah,
I know, yes, I do.
You know, yeah.
The answer
Yeah,
is zero, for sure,
yeah,
for sure.
yeah.
0 times.
Yeah, yeah.
How many
So
times
it is-
has Nathan been suspended for making a staff member feel, quote, unsafe, absent any threats or physical violence? How many times?
I couldn't tell you. No.
More than one, right?
Yeah.
Yeah.
More than 5?
That's
I
reasonable.
don't know about that. But
Yeah.
It's
I don't know,
100% definitely more than 5. Yeah.
Okay.
So, I mean, you
So
guys
that's-
don't-
Your concern is we're not treating staff and students the same, is that what is, I mean, just from where you're coming from,
Yeah,
right?
yeah.
If they have a feeling they're unsafe, we investigate and we follow through with consequences.
No,
If-
you never follow through with consequences.
Okay.
Yeah, when
Okay.
staff...
I'm talking about with students, if that's the case, but we don't do that if a staff member is making a student feel unsafe.
So it's like this, right?
Mm-hmm.
If a staff member says something, there's 0 investigation,
Mm-hmm.
unless I request an investigation. So there's 0,
okay.
0. They get
I
suspended.
can't, yeah.
They get suspended,
can't
and then
speak to that.
when it comes to the children, if they feel unsafe, and again, we're talking about subjective feelings here. We're not talking about objective facts. Then there's an investigation into the objective truth of the matter,
Okay.
of whether something was impropriety or not. And there's there's 2 separate standards. I mean, would you agree?
I don't think there's 2 separate standards.
You literally said
I
there
really-
was 2 separate standards like 2 minutes ago, like less than 30 seconds ago.
No,
No, I mean, we investigate all of these claims, right, to the best of our ability to try to get the students' side of things, understand their experience, but then also, right, we get information from other students and staff to establish some objective.
Perhaps I'm bad at explaining myself. You guys punish students based solely on staff discomfort or perceived disrespect, right?
Solely?
Solely. Yes, solely. When you punished my son for saying, Miss Bachmeyer, you're a bad principal.
We verify that those things that were like reported that you said, like we verify with other students that those things were said, that you can, right, to create that objective.
No, but the punishment isn't for an objective behavior. It's for the feelings of Miss Bachmeyer. Because I have other situations, and I'd be happy to pull out the emails for you, where Nathan said the exact same statements to staff members, and they said, nah, it's not that big of a deal. I don't care. And he didn't get punished. He didn't get punished. Several emails, in fact. I mean, again, I'd be happy to give you guys those emails, right? I'd be happy to do it. There are, of course, internal emails, but it's like, it is obviously subjective based. That's what you guys just told me less than 2 minutes ago. And so now that we're kind of getting caught into a rough position where we obviously have 2 different standards, now we want to talk about objective. And it seems to me like you guys are backpedaling here. It's not actually,
okay.
do you disagree?
I disagree. I mean, I wasn't involved in the whole, I mean, in some of the investigations, but yeah, I mean, if they're investigated, they're followed up on. That's what I'm gonna say.
They're investigated, but you're not aware of any of these investigations, right, personally?
I remember the one hip piece, but maybe not everything that's happened, so. And we're in here talking about this specific incidents, right? This specific discipline, because that's the process. We're here to listen to what your concerns are about this particular incident. And from what I can gather, I mean, just for me to sum up, because I'm late getting to this other meeting, that what I've gathered is the main concern is that you don't feel that this long-term suspension is warranted because we're not meeting the standard of a long-term suspension.
That's correct.
Based on like danger, safety, those sorts of things. In general, is that okay?
Yeah, that is.
Okay. And we'll take a look at that.
I do appreciate that.
Yeah.
And just so you're aware, I'm not going to make a claim right now. Here in the very near future, I'm going to do what's called a discovery request. I'm sure you guys are familiar with what those are. Basically, I can get a hold of your like internal emails, all your like your calendars and stuff. And the last 2 meetings we've had, you guys have told me both have had meetings right afterwards. So I just want you to know that I'm going to check.
That's fine.
And so I really hope that there's a meeting on your calendar.
There's a Zoom.
Okay, I hope that's true. I hope that's true. You can't blame me for questioning.
I can't.
There's been a lot of deceit,
but
right?
Yeah. We got to stick. Obviously, we've got to stick to our other appointments as well, just like we stuck with yours.
Yeah. No, I get that. I'm just obviously with the trust issues that I have with the school at this point. Again, lots and lots of deception has been afoot for over a year and a half. When someone tells me something, I just can't take it.
You don't have the trust.
Yeah, exactly.
I got it.
I wish I had trust. I wish I did, but I just unfortunately don't.
Yeah.
So I think that pretty much covers actually all the things I wanted to go over.
Okay.
Do you guys
we'll get back to you on the long-term suspension piece. Okay. And so yeah.
And can you guys please try and make it as quick as possible? Again, my son's been out of school. Again, we're coming up on a month of no educational, nothing whatsoever, and he needs to be back in school. I understand you guys don't like the audio recording device, and again, we can argue this in court whether those things are admissible or unadmissible. That's fine. But the reality is, based on the 14th, we know he can be at school. He can have his device where it's recording his staff interactions only. Again, we are totally cool with limiting where he's recording in reasonable things. Like if you guys don't want him recording in the office, that's totally fine. That's fair. You guys don't want him recording in the nurse's office, counselor's offices, the bathrooms. These are all fine, acceptable things. We only care about the objective record between staff. So like we know based on the 14th email and his behavior of that day, he can come to school, he can act like a normal kid with no disruptions or anything, and we can have an objective record. Again, I will never in a million years share any kind of recording he pulls out of this school publicly. I will not do it. So like, it's straight up for you guys to listen to figure out the truth. It's not meant for the ears of anyone else. That's it. And then whether or not it's like admissible under law, like in court, that's a question for the judge, right? The judge will make that determination, right? But you guys can and should listen to objective recordings from these kids, because imagine being so powerless, right? You're a kid, a teacher says something, it's objectively false, right? And you have a recording. You could prove them wrong, but the staff is like, no, we're not going to listen. I think that there's no logical reason at least, to not listen to these recordings. You should. They're just for your ears. You don't have to share them with anyone else in the school. You can keep them private to yourself. I'm just asking that they be considered during the appeal so that we can get to the underlying truth of the matter. I don't know. It doesn't sound unreasonable to me.
Okay.
Awesome.
Good there? Okay.
Thank you.
Yeah.